and we're set to go.
Thank you, Angela. I appreciate you getting us all set up with this again, and working with, of course, the new Zoom requirements of having a room that you let people into or providing passcodes. So we're working it this way right now, and anyone that's joining us, if you have any feedback on how we do the Zoom presentation, please let us know. So as we suspected back last Monday, that Governor Mills may issue another emergency order proclamation for a state of civil emergency, she did. And she did it on September 30th, and it's issued for another 30 days. So I guess we'll be looking at where things stand on October 30th of this month to see if we get extended again. The other thing that is new that was also issued on September 30th was an announcement from the Administrative Office of the Court of the Maine Judicial Branch, and that was an update on the Tyler Technologies breach, essentially updating us from a week earlier on where Tyler Technologies stands and our restart of our e-filing process in District 5. And the update essentially said we're going to have to issue another update. But it was very nice of them giving us an update. I did talk to someone from the judicial branch, and they were indicating to me that, and Justice Mullen might have some more insight on this, that remember I said I was reading between the lines in the last announcement that it seemed like it was a resource issue for Tyler Technologies to keep helping us in this state because they needed to apply their human resources to taking care of the breach. One of the things that I had heard that might have been an issue too related to resources is that the breach caused Tyler Technologies from the top down to change the way they interfaced with their customers too, as far as interfacing by computer or having to do more telephone work. So for all those reasons, I guess Tyler needed to assess their human resource capability. And then I wanted to do a shout out for our family section because I know it was from some of their inputs that were shared with the judicial branch that there was a change to PMO SJC 3 issued on the 28th of September related to what can be submitted through the proposed orders at courts.maine.gov email. And it was adjusted to reflect that not only Word format editable versions of a proposed order should go through that portal or that email conduit, but also that uneditable child support orders or things related to proposed orders that on forms like child support orders and child support worksheets can be sent uneditable. At least that's my reading of it. Oh, okay, no. So correction, I'm looking at that again. You get it, after you read it 3 times, you get a different meaning. It looks like it says you need to submit the child support orders and child support worksheets in an editable format. It just doesn't have to be Word editable. So that's the change on PMO SJC 3. And with us today, we are very fortunate to have the Chief Justice of the Superior Court with us, Justice Robert Mullen. And I appreciate you joining us, Justice Mullen, and that we hope to get some more insight as to what's been going on with the Superior Court, and maybe even your thoughts on how the active retired might be accessible coming on board, and any spots that still need to be filled too. How that manpower part's going to work, if you know anything about it. So with that, Justice Mullen, thank you for joining us. The floor is yours.
Thank you, counsel. First of all, I guess I want to start by thanking the Bar Association for the invitation to appear here today. Part of my prepping for this was to talk about the jury selection process that we have at present. But I'm happy to discuss whatever topics, concerns, areas of inquiry that people want me to bring up, as long as they don't get tired of me saying, that's a great question, let me get back to you on it. I had prepared some notes about jury selection, so I'll just dive into those. But if you want to have questions as we get as we proceed, or if you want to do it at the end, it doesn't really make any difference to me.
And Justice Mullen, thank you for bringing that up. I just want to refresh everyone that if you do have questions, please type them right into the chat function, and we will share them with everyone and Justice Mullen at the same time, so that we can all see what it is that you have for a question. Thank you, Justice Mullen.
So I guess we start with the question, or at least I would start with the question: why are we exploring the possibilities of having jury trials in a pandemic? And there are a lot of reasons. We could spend a lot of time discussing the reasons, but I mean, it seems like to me, you have to start with the fact that a person has a right to a jury trial, which is one of the most fundamental rights that we have. My comments today are primarily going to be addressing criminal jury trials, but we haven't forgot about civil jury trials. Just one of the problems is having the criminal justice portion of jury trials being suspended for going on, I think, 7 months. It's created a significant backlog of criminal cases that we have to address before we feel comfortable starting to consider jury trials in the civil form. Obviously, we have a backlog in civil jury trials as well, but criminal takes precedent. We've been able to have jury selection and trials in 2 locations up to now, Augusta and Bangor, and you probably know that, or most of you are probably aware of that. Augusta selected 2 trials, or juries for 2 trials, only one which was able to go forward because of a COVID concern involving a witness after the jury was selected. The other trial that proceeded ended up in a hung jury after they were out on a Friday afternoon for, I think, over 5.5 hours. The jury was interviewed afterwards by the presiding justice, and they seemed to feel very good about the process, seemed to feel very safe during the trial, and so that was considered a success by us. The second trial is a murder trial up in Bangor, which wrapped up the evidence on Friday, and I think may be deliberating or will be deliberating sometime later today. That trial began with the jury selection process on September 21st, and I don't believe it started the actual trial until September 24th, so it was significantly longer. It's still going on, so it's significantly longer than the Augusta trial, which took 2 days. The Augusta process, though, exposed, I want to say, maybe 40, and then maybe an additional 20 cases. So perhaps a total of 60 cases that were exposed to trial, and a very significant number ended up being resolved in pleas. There were at least one bench trial I know that went forward. So we got rid of a lot of cases, or resolved a lot of cases in Augusta. Now, it wasn't a coincidence that the 2 locations for our first trials with the Capitol Judicial Center in Augusta and the Penobscot Judicial Center, because both facilities are our best facilities, frankly, for conducting jury trials in a COVID world, certainly in terms of space. Both locales have sent out approximately 500, I believe, jury summonses, along with what's been referred to as a COVID questionnaire and a very simple constitutional questionnaire with a request to get the questionnaire back to the respective courts within a very short period of time. I believe it was 5 days. The questionnaires were gone over. The questionnaires were accompanied by a note from the court explaining the precautions that the court was taking for the health and safety of the jurors as well as everybody else involved in the trial. Some people, based on their answers to the questionnaires, were eliminated from further consideration at the outset. For those who were not, they were brought into their respective courthouses, keeping in mind the COVID maximum capacity restrictions, and they're given a case-specific questionnaire. The case in Augusta was actually an OUI, so there was an OUI questionnaire passed out, and there was a specific questionnaire concerning the homicide trial handed out in Bangor. And eventually, based on the results of those questionnaires, more people were vetted out. And then eventually voir dire was conducted with acceptable juries being selected for actually 3 cases. I forgot, Augusta actually had 2 cases selected, but one, as I said, because of a COVID-related concern, didn't go forward. It had nothing to do with the jury or the court personnel, but there was I believe it was a child of one of the witnesses who was tested. They didn't have the test results back, and so anyway, a decision was made to continue the trial. We know so far that it's a very time-consuming and resource-heavy process, meaning that you have to have more marshals than usual, more clerks involved than usual. You've got multiple courtrooms being tied up. Almost every aspect of the process, probably not surprisingly, took a lot more time than in a pre-pandemic environment. But I think it was a success both in Augusta and Bangor. Another reason why Augusta and Bangor was selected is because they had the advantage of large rooms compared to other court houses in the state for jury assembly as well as jury selection. Plus, there was an availability for discussions among the court and counsel outside the presence of the jury, which is simply not as accessible in smaller courts such as Farmington, which I was there last week. Based upon the information presented so far by the justices conducting the cases, Justice Stewart up in Bangor and Justice Murphy down in Augusta, I think both matters should be considered a success. The question now is, well, where do we go from here? There's a jury management group consisting of different judges from the Superior and District Court, and headed up by Justice Warren down here in Portland, that's been instrumental, frankly, in studying the situation, all the different issues that come up, and making recommendations to the law court as to which regions should be or could be or should be considered next for trials. That is a process that's going on literally as we speak, and I'm hopeful that a decision can be made shortly as to where we go from here in terms of which courts that we feel we can safely open up for jury trials.
Justice Mullen, I have a couple of questions.
Sure.
The first one is, what were the COVID-related questions that disqualified jury members, and who fashioned the questions?
The questions were fashioned by the court. And of course, I had them here somewhere. Now, okay, here we go. They were questions that basically went to, is there anyone residing in your household that has a higher risk of developing serious complications from COVID-19, either you or yourself? Do you live with or provide direct care for a person vulnerable to complications? Do you have children at home who require direct supervision if the schools or daycare remain closed because of COVID-19? Questions, some of which were not unlike what you're asked if you go before you go into a courthouse. And it was pretty self-explanatory, I think, that if you answered yes to these questions, then you were not going to be considered any further for consideration, whether or not you had any concern yourself, irregardless of whether or not you had any contact with COVID-19. Just the fact, were you going to be able to focus on a trial if you came to court? And so those questions were the answers to which it was decided who was and who wasn't we're going to bring in. One of the ideas behind the questionnaires were to ask them early on before you brought jurors in, because of the numbers restrictions in courts. We didn't want people coming in that were almost absolutely going to be excused almost immediately, depending upon the answers to these questions. So the decision was made to send out the questions first, so that we wouldn't be taking up spaces by people who I think all felt pretty comfortable we're not going to be able to go through the process based on the answers to the questions. So that was the genesis of the questionnaires.
The other question I have is, are active retired being brought back to court to work cases?
That's a great question. I actually have an answer, but the problem is initially, obviously everyone is concerned about budget issues. And so initially there was going to be there was an issue as to, are we going to have any money to pay for the active retired judges? It's certainly been said multiple times that they're the best buy in town, but we're very unsure about what the budget was going to be. Recently, things became clarified, so it looked like we have some money for active retired judges. We are going to try to bring them back, but the problem is, are we going to have support staff, marshals and clerks, in order to run extra courtrooms, for example? I mean, it would be great if we had the space and the resources, support resources, to have extra arraignment sessions, for example, because and if we have time, we'll get to that. We're falling behind every week on our arraignments. We were able to catch up with the arraignments that didn't take place while the courts were shutting down during the late spring, early summer. But now, and that was in part because the numbers of summonses and arrests were way down. Now it seems almost universally across the state that the number of summonses and arrests are approaching at least pre-COVID levels, if not we're there. And so when you can't have mass arraignments anymore, and by mass arraignments, I'm saying it wasn't rare to have 100 people summons in for 8:30 in a particular courthouse for a particular morning. And we could get through those. But you obviously had people sitting maybe 6 inches apart as opposed to 6 feet apart. Well, now you can't do that, simply can't do that. And so we're falling behind. And so it'd be great to have multiple arraignments, but, and we could staff those with active retired judges, but do we have multiple courtrooms? Do we have multiple marshals? Do we have multiple clerks? And the answer is we don't. And so someone said to me, and they're absolutely 100% correct, the issue you're going to find is not so much having the ability to pay your active retired judges as it is to have the support people and facilities in order to have more going on than what you already have going on. So the answer is yes, but to what degree and what extent, that's being worked out. I hope that answers the
Yes.
question.
So, Justice Mullen, what about phase 5? How are things? What's the plan?
Well, the plan is to gradually open up as quickly but as safely as we can. And, you know, sometimes those are in conflict. Where arraignments are, as I said, we're already falling behind in arraignments. We are working with law enforcement and the district attorney's offices and the attorney general's office to see if there's some way we can have a more comprehensive, let's say, approach to arraignments than what we have right now, which is just the court system well, we've never had really any control over the number of arraignments we have on a particular day. It's just, it depends on you know, what was going on in the community and how active the police were, how active the crimes were in terms of numbers of arraignments and the summonses. We simply can't do that right now without falling behind farther and farther. So discussions are ongoing to try to figure out, you know, what's a more studied approach to trying to make sure that we don't have to re-summons people, making sure the clerk doesn't have to reschedule people's arraignments. There's multiple reasons why that is not a good approach for anybody. Probably starting with if a clerk, there's an area somewhere in the state tomorrow which has like 128 arraignments set for the entire day, spaced out in a morning and afternoon session. But the problem is you can get in to arraignments probably 10 to 15 people per hour. You remember you have to show the arraignment tape or give people their arraignment rights before every session. The reason why you can only do 10 or 15 in most places is because of the size of the courtroom and with social distancing and with a clerk and a marshal and a judge in the courtroom with the DA and with a lawyer of the day. That just limits the number of people you can have in most courtrooms in the state. And so then you schedule people from 8:30 to 9:30, then another 10 or 15 from 9:30 to 10:30. Well, unless you get done with the 8:30 arraignments early, you're going to run behind because you've got to advise people of their rights. The clerk is rescheduling, you know, the majority of people who are set for 8:30 to another time during the day, or even worse, another date and time. You can imagine the reaction of people who come in thinking they have an arraignment at 8:30 and they haven't gotten the letter because they've moved or the mail is slow or what have you, only to be told that, oh, your arraignment's at 1 o'clock, or oh, your arraignment's not today, it's next month. And so it is a challenge, let's say. And so we're trying to address that. We're trying to, you know.
I have a couple more questions.
Yes.
From a CDC standpoint, it appears that judges and jurors are reasonably well protected, but is the court satisfied that the other participants, like the attorneys and the defendants and the witnesses and police, et cetera, can be similarly protected?
I think it's fair to say that nobody in the judicial branch, much less a presiding judge, is going to want to go forward if they have any concerns that all necessary precautions have been taken so that people's health and safety are considered to the greatest extent possible.
Okay.
And speaking for myself, I don't. But like I said, I'm confident that no one would want to go forward with something where they think that the attorneys or the litigants, certainly the jury, if we're talking about a jury trial, or the clerks or the marshals or anybody, no one wants to play poker with someone's health and safety.
So you've talked a lot about arraignments, but what about civil cases?
Good question. What about civil cases? Right now, at present, what the judicial branch has tried to do is allocate responsibility for criminal matters to the greatest extent possible to the Superior Court. So as hopefully to free up the district court to address their backlog of cases, which should not be minimized. I mean, family cases, PC cases. I mean, I was a district court judge for 17 years, so believe me, I empathize with having a backlog of any of those very important cases that we had even pre-pandemic. And obviously, when you shut the courts down, like I said, for a series of months, I should have known better. I probably should have expected the depth and seriousness of the backlog, but frankly, I didn't have a complete understanding of just what a challenge it would be if we just shut the courts down for what it seemed to be not a terribly long time, but the backlog is very significant. So the district court is trying to work on their cases. We're trying to do, we being the Superior Court, is trying to do the criminal backlog and all the events for criminal. Try to take responsibility for those as best we can. But there are some places where we just don't have the judicial resources so that that the Superior Court can do everything criminal. Sometimes the district court has to help out, and of course, if they are asked to help out, and they're great doing that, but that leaves somebody not hearing a child protection case or a family law case or other matters that they could be hearing if they didn't have to help out in criminal. So,
Justice Mullen, I really appreciate all the thoughts and the time that you're giving us. I'm worried that we might be running out of time before we just wrap a little bit. If there's something that, we are out of time. So if there's something that you'd like to share with us, please do. I just wanted to throw out there that if you had some sort of inside scoop as to when you think the e-filing process might resume, we'd be curious in that too. But any final words?
Let me, as far as the e-filing, it seems like every day I think, oh, well, what else could go wrong, or nothing else could go wrong, and then some crisis hits us. And so e-filing was just, unfortunately, like another day at the office. I'm hoping that can be rectified. I think, it would be irresponsible for me to say, oh, in 2 weeks, we're going to be up and running. I'd like to think that, but it really depends on how quickly Tyler can address its issues so that we can get up and running. I can say with 100% confidence that we were ready to go, and literally on the eve of e-filing, this happens. So, but I have faith in Tyler. I have faith in their people. I think they're going to get their house in order for a lot of reasons. We don't want to go forward, however, until we know that it's going to be safe to do so. So, as far as e-filing is concerned, I think it's a delay, but it's just another challenge that we have to face, and I'm have 100% confidence that we'll be able to do so. In terms of judicial vacancies, I know people are wondering about that. It's impossible to do things in terms of appointments without the legislature in session. There are a lot of reasons why the legislature isn't in session. The governor's office, is aware and sensitive of the vacancies, and again, I have a lot of confidence that they'll be addressed once once we have the legislature back in session, and the governor can make her nominations. I guess I'd just end in saying that the challenges are very significant on almost every level. They're not disappearing apparently anytime soon. But I think the consequences of just sitting back and hunkering down and not doing anything are just not acceptable if we're going to have any type of system of justice. And so I think we're going to be able to address people's constitutional rights while at the same time, keeping in mind and doing to the fullest extent possible, making sure that people's health and safety are on equal footing, if not paramount, to people's court rights. We've been challenged before. I'm prejudiced. I've lived in Maine all my life, and I think people in Maine, I wouldn't live anywhere else because I just think people just kind of grit and bear it. That goes for the attorneys as well as the litigants and the judges and the marshals and the law enforcement. I'm just never fail to be impressed with the challenges that we have, and we're all addressing them. Even my favorite football team lost their quarterback to this, but we're going forward tonight, and we'll see what happens. But I just hope everyone can just bear with us, take a deep breath. I'm as frustrated as everyone else is at the process and the slowness, but we will find our way. The other thing is, if I realize we haven't had much time here today, and I'm sure there are questions which people would like to ask. I would say send to my email, but it would just blow up. But you can send any questions to the Capitol Judicial Center, 1 Court Street in Augusta, and I will get back to you. It may not be within 24 hours, but I will get back to you to acknowledge what you've sent. And if I've got an answer, I'll be happy to give it to you.
And Justice Mullen, thank you very much. We do have a method here where our association forwards your communications director, Amy Quinlan, questions all the time, and you guys are great at when you come on giving us some answers to those. We did have one last question, but I think it might just put you on the spot if we were going to leave you with it. And that was, there was a change where you stopped allowing e-filing of motions and things like that allowed people to stay away from the courthouse during the pandemic. And if you had any thoughts on that right now to share with us, we'll take it. Otherwise, we will forward it through Amy Quinlan.
Well, certainly you can forward it because you might get a much more thorough response and probably more of a coherent response than the following. But what I would say is this: I completely get it. I know it made sense during the summer, but it's kind of inconsistent with opening up the process and opening up the courts if we're going to be taking filings through the email. Plus, it's just a lot of extra work for the clerks. if you take nothing else from this session today, tell your clerks when you go to court, if you go to court or virtually, that you just thank them and appreciate what they're doing, because they didn't sign up. I mean, none of us signed up for this, but the clerks especially didn't sign up for what they're going through now. And eliminating the e-filing was an effort to try to reduce to a degree the work that they have to do. And so, but if things get worse, then I think everything's on the table, and we'll consider, all the different options we have to try to plow through this. But the elimination of the filing by email, I think was, in part anyway, a recognition that we just can't continue to pile stuff on the clerks and expect things to run, according to the new normal, let's say. So.
Well, I really appreciate it, Justice Mullen. Thank you very much for indulging us one last question, and for being with us here today. And we will forward questions, your way in the future. And I appreciate your openness. We're going to wrap up in about 30 seconds here with Angela coming on board with business comments for the Maine State Bar Association. And you're welcome to stay if you want to, Your Honor. I know you're a busy person. Thank you.
Thanks, Justice Mullen. I'll be very quick. There is no bar talk next Monday because of the holidays, so please do not try to join us. We will pick back up the following week on October 19th with Jim Cohen, and then the following week we will have District Court Chief Jed French. Again, a reminder to provide us feedback referencing the September trainings that Tyler Technology held. We've received some feedback. We'd like to get a little bit more that we can provide to the courts. And finally, I just want to bring this to your attention. We've heard a little bit about this counterfeit check scam that a couple of attorneys have experienced in Maine. I've heard it's happened in some other places across the country, but basically it looks like an attorney gets a legitimate solicitation email from a prospective client seeking representation in a matter, for example, a family matter, to collect arrearage of spousal support. And then you get the name and address of the opposing party, and it states that they'll pay the standard fee. And then there's email correspondence from the client indicating that the ex-spouse has agreed to pay the arrearage and asks the lawyer, and that a check will be coming. And it asks them to deposit the check, take out the legal fees, and send the balance to the prospective client. And then within a few days, you get a transmittal letter from UPS or FedEx, so legitimately through those means, from a person claiming to be an account manager for the spouse. And they get a seemingly valid bank cashier's check. And in this case, the attorney got a $350,000 check on a JP Morgan Chase bank account, and everything looked really legitimate. And what ends up happening is the check never clears. So if you get a big check like that and everything seems legitimate, you might want to just double check on it before you try to cash that check. We will also be sending out a more encompassing information in an e-blast for members to just be aware of this. Thank you. Thank you,
Angela. And I just want everyone to remember our Native American or Indigenous Peoples Day coming up on Monday, and to think about how they used the earth, they cared for the earth for future generations. All right, we'll see you all on the 19th of October, and look forward to any comments you send us. We'll get them channeled to the judicial branch. Thank you for joining us, everyone.